Welcome everybody to this seminar organized by the Center for Comparative and Public Law. I'm Kelly Loper, director of the center, and I'm very pleased to welcome and introduce Professor Lech Garlicki, who, it goes without saying, is no stranger to the Faculty of Law at Hong Kong U. He's a former judge of the European Court of Human Rights. He's a professor at the University of Warsaw. He's been a visiting professor at many prestigious law schools around the world, luckily including our own here at the law faculty. And he's made tremendous contributions to teaching on our LLM and human rights program. He's been an active member of our editorial board of the Asia Pacific Journal on Human Rights and the Law, which is housed within the center. And we're very pleased to welcome him back to Hong Kong U. He has also given a number of excellent lectures on his visits in the last several years, and today I'm sure is no exception. He's chosen, as usual, a very timely topic and also an intriguing title, to bark or to bite the European Union, its member states, and the rule of law. So please join me in welcoming Professor Garlicki.
Is it working? No. Thank you, Kelly. It's always a great honor and a great pleasure to be here. I like Hong Kong. This is my fourth teaching visit to the place, and even if this time the reception was a little bit on the cold side, still I like being here. So what I am going to talk about is some rather bizarre mechanism within the European Union dealing with naughty boys, maybe also girls. Kelly was so nice to mention that I am from Poland, and Poland in the European Union had a very interesting development. It started as one of the best students, and when it was predicted which of the East European countries or which of the post-Soviet countries are going to make it, Poland, probably next to Hungary and Czechia, were always mentioned as, okay, this is clear, and then the rest. Then, unfortunately, since 2 years, Poland rather joined the group of naughty boys, which Poland is not alone. Hungary already belonged to this group, or founded this group in 2010-2011. The Polish developments are relevant for what I'm going to talk about, because it is a context. So there were elections in 2015, perfectly democratic elections, which moved the parliamentary majority in both chambers of the parliament, as well as the presidency, to the opposition, who now becomes the leading and ruling party, which was nothing unusual, because it was usually so from one election to another in Poland. However, this time the new majority decided to change almost everything, and it began changes. They did not have constitutional majority, so several of these changes were, let's say, problematic from the constitutional point of view. Very wisely, they decided to eliminate first independence of the judiciary, the constitutional court, and then the other courts, assuming that once they are in the control of the judiciary, no one will be able to tell that something is unconstitutional or unlawful. This produced, of course, a lot of different controversies inside the country, outside the country, but this also brought somehow in a daylight the question how much leeway is left for those countries who are already members to the European Union in introducing changes which are at best problematic when confronted with some basic values of the European Union or some basic assumptions of how this union should work. Maybe one or two brief informations about the EU as such. This is sometimes a little bit confusing for those who are not insiders. There are two supranational organizations or integrational organizations in Europe. There is the Council of Europe, which is a universal organization, which is known from having the European Convention on Human Rights and the European Court of Human Rights, but this is of no interest for us today. And there is the European Union, who is still composed of 28 countries, probably not for a very long time, it may be 27 quite soon, and which is a different organization. It's a supranational organization with very wide powers to deal with several questions which traditionally have been reserved for a national government. So it is much more than an international organization. Now, the European Union developed constantly, starting from the so-called European communities in the end of 1950s. In 1992, there was a Treaty of Maastricht establishing the European Union, and then there was a series of further treaties, Treaty of Amsterdam, 1997, Treaty of Nice, 2000, an aborted attempt to adopt a constitution for Europe, and finally the Treaty of Lisbon, which is the most recent achievement which entered into life in 2009. This development was accompanied by territorial enlargement. The European Union of today, it's much larger than the original 6 countries who started the arrangement, or 15 countries which existed before the Eastern and Central European countries joined. So that was, in a sense, a double enlargement. The one was territorial enlargement of the Union, but the other one, also very important, was the enlargement of powers and competencies. Again, all these treaties mentioned before are or were treaties usually giving more powers to the Union, to the different organs of the European Union at the expense of the national states and national governments. These powers went far beyond the original concept of a single economic market, which was developed for the European communities, and with more and more decisions and measures taken or decided by the Union, also the question emerged whether the Union as such should have some developed guarantees concerning rule of law, fundamental rights, fair procedures, etc., etc. These two types of enlargements and problems began to be seen also in the relations between both the member states and the quite complicated system of bodies within the European Union. Again, just a very brief sketch. The European Union is organized as far as its central authorities are concerned on some kind of separation of powers. There is the European Parliament, elected in popular vote by in all member states. Then there is the European Court of Justice, or Court of Justice of the European Union, and this too is simple. As far as the executive branch is concerned, there is a combination of autonomous bodies of the Union, and this is the Commission of the European Union, quasi-government, let's say, acting on a daily basis in Brussels. However, several important decisions are taken by two intergovernmental bodies. The one is the Council, which is generally speaking composed of ministers or deputy ministers responsible for particular areas. And finally, there is the European Council, which is the highest body composed of presidents or prime ministers of all member states. So this is slightly complicated, but let's try to keep it in mind. Now, as far as relations between the member states are concerned and the Union, the treaties are very clear. There is a principle of so-called sincere cooperation. So both sides are expected to cooperate loyally in the implementation of union law, but also in respecting of what is left for the sovereignty of member states. This developing and ever developing net of regulations, contacts, measures between the Union and member states, of course, had to inevitably, it had to bring different disputes, questions, problems, and this was from the very beginning inculcated in the system. The treaties provide for so-called infringement procedure. Infringement procedure, in a, let's say, very rough simplification, is that the European Commission, or also some other bodies, may start proceedings against a member country which does not observe obligations resulting from the treaties. The first part of this procedure is political. The Commission tries some kind of negotiated settlement. If it's not working, then the case may be sent to the European Court of Justice, and the European Court of Justice may decide that a particular country has infringed upon its obligations resulting from the treaties. Then what? Then the court has also a power to impose a fine. And for example, Poland has recently been found in infringing some prohibitions dealing with environmental protection, 100,000 euro per day for not observing decision of the court. So in this sense, it could be quite persuasive. But this is, let's say, a mini dimension. This is a dimension where there is some, let's say, regular obligation, and there is a dispute to what extent this obligation should or should not have been observed in a particular manner by the member states. The other dimension is the question, but what to do with a country which does not behave generally? What to do with a country which pursues some policies which may not be in an, let's say, a clear violation of the treaties and clear violation of the obligation of economic cooperation, but are in violation of some more general values, rule of law, of course, being one of those. The initial answers in the end of 1950s was that there is no problem, or there should be no problem. The European Union or the European communities were meant as an organization of economic cooperation. As far as human rights, rule of law was concerned, this was for the European Convention on Human Rights, so another structure. And those countries who were in the original composition were all the democracies, and again, there was a very strong presumption that they will not get crazy one day. Then slowly with the territorial development of the Union, and particularly with the prospect of enlargement, geographical enlargement of the Union, it was realized that maybe it's a good idea to at least write down in the treaties of some general values. And this was the genesis of Article 2 of the Treaty on the European Union, which you have in these materials or in these leaflets which were distributed. Article 2 was, let's say, enumerating basic values of the EU: respect, human dignity, freedom, democracy, equality, rule of law, respect for human rights, including the rights of persons belonging to minorities, again, non-discrimination, tolerance, justice, solidarity. So wonderful, wonderful dictionary of nice things, as all articles placed in the very beginning of constitutional instruments. This was rather regarded as some kind, let's say, of enumeration of intention. But on the other hand, it was clear from the very beginning that once the post-communist countries have joined the European Union, there may be problems. They may be problems simply because there were different traditions, the different patterns of governing, etc., etc. So the question was how to react in such a situation. Again, still there was nothing in the text of the treaty. In 1997, the Treaty of Amsterdam provided for the first time for the procedure of suspension of some membership rights of a member state in situation in which this member state would gravely violate obligations resulting from Article 2 of the treaty. It also should be mentioned that the treaty on the European Union does not have any procedure allowing the Union to expel a member state. This is the difference comparing to some other international organization. This suspension of some membership's rights was regarded as a new procedure or new guarantee. From the very beginning, however, it was criticized because it was very complicated politically. I come back to this in a moment. And this was called a nuclear option. Because if the only way to react was to suspend some membership rights, this, of course, would immediately produce politically a very complicated situation. Then, in the beginning of 1990s, again, the enlargement was closer and closer, and at the same time, there was a short episode of very right-wing parties getting a strong position in the Austrian parliament. Parties led by one Mr. Haider, which resulted in some kind of quasi-sanctions imposed on Austria, or rather Austrian politicians, with a clear message: we do not like this party in the government. Whether it was fully compatible with international law, it's not clear. But very soon some kind of settlement was found, and Mr. Haider finally was not as dangerous and not as monstrous as it was presumed. But the lesson was that now this may also repeat in other countries, and still the treaty leaves for the European Union a very complicated or complex alternative just to criticize, namely to bark, or to use this nuclear option, so maybe not a bite, but just kill a country which would not follow this Article 2 values. So the political decision was twofold. The one was a development of so-called accession conditions, the so-called Copenhagen conditions, namely all countries who wanted to accede to the European Union must be had to be accepted by the European Union as meeting certain minimal requirements of democracy, rule of law, etc., etc. As long as such a positive brief was not given, there was no possibility of accession. But as far as those countries who already were in the Union, now another mechanism was added, so-called warning mechanism, so not the nuclear option of sanctions, but some early warning mechanisms allowing the European Commission and the European Union to tell to those countries, don't do it, we see what you are doing, this is not a good idea, etc., etc. Again, the question was whether this was a working mechanism or not. This was all very abstract when it was adopted finally in the beginning of 2000s. The story erupted in 2010 when Hungary was taken over by another anti-democratic populist party of Mr. Orban. Then there was a talk, so again a little bit of barking, whether this Article 7 mechanisms should be put into motion, but that was difficult to decide it. Well, the problem with this mechanism is that they are very heavy. The mechanism for the warning procedure is purely political, so there is no participation of the European Court of Justice at all. There must be the initiative of the European Commission. Okay, this is not difficult, but then it must be accepted or confirmed by both the European Parliament and the Council of the European Union, which of course Council, it requires I think 4/5 majority in the Council, so this is a political decision which should be taken by most member states, and the only effect is recommendation, which does not have any binding value. For the sanction mechanism, this is even more complicated, because then more or less the procedure is the same, but the decision to start the sanction proceedings belongs to the European Council, so the meeting of all heads of state, and must be taken unanimously. So one vote against, of course, the affected country cannot vote, but one vote against from other countries results in abortion of the whole procedure. Again, no participation of the Court of Justice. Then in 2014, under this not very, or after this not very acceptable experiences of Hungary, the Commission decided, oh, maybe we can do something by ourselves. And they invented the so-called early warning mechanism, which is a mechanism which practically is concentrates all decisions within the European Commission. The European Commission can start it, can find that there is a problem, and can give recommendations to the countries. And if it's not working, can start this warning mechanism and sanctioning mechanism in the further notice, which of course put the Commission in a stronger position than it had before. But still, it has not been tested in respect to Hungary. The first test came in 2016 in respect to Poland. The reforms, so-called reforms of the judicial system, were not digestible for other union members. So the political decision was that the Commission should start the early warning procedure. They started this procedure. They issued several recommendations 3 or 4 times. It was not followed, so that was it. Once the newest set of anti-court legislation was adopted in Poland, the Commission decided, let's start now these formal proceedings, the warning proceedings, namely the Commission now presented the motion to the Council of the European Union to formally find that there was a violation of values from Article 2 of the Convention, and then the Council would also adopt some kind of recommendations addressed to Poland. Whether it will be heard, I'm not sure. Whether it will give rise to the third option, nuclear option, namely suspension of some membership rights, that it's impossible to tell. But as it requires unanimity, and our Hungarian friends already promised that they will not vote for such a procedure to be applied to Poland, of course under the assumption that Poland will not vote for such procedure applied to Hungary. Again, this whole procedure does not look as efficient as it could have been presumed when it was drafted 15 years ago. So, what next? This is, of course, a very good question. There are some debates proposing, let's say, less nuclear options, but still very painful options. Of course, the most painful option is to cut the money. The budgetary system of the European Union is that they are countries which pay more than they receive back from the Union, and that there are countries that pay less and receive more. And it's easy to guess these new economies are rather on the side of those who are given money, generated somewhere else. I think Poland is, in this budget, it is about 50 billion euro. So it is not an insignificant money. So to cut it. But now the question is how to do it. The EU law does not provide for any procedures to cut money based on, let's say, bad behavior in human rights. Had there been a problem with the economy, this of course is another, but Polish economy is flourishing. This is one of the reasons why the majority of the population is quite happy with all this, what is going on. So the first idea is there will be a new budget adopted in 2 years. New budget, of course, allows a lot of leeway and discretion for the European Parliament. This may be used as a kind of leverage to at least press the Polish government not to do certain things, which is not impossible because with the quite real perspective of Brexit, the budget would shrink anyway. So now, who will be losing and how much? This will be political decisions which will have to be taken anyway. Then another idea is to adopt some kind of regulation which would allow to combine use of funds of the European Union with correct observation of values of the Article 2 of the treaty, particularly with the correct observation of the rule of law. Then there would be a legal basis for cutting funds in situations like now in Poland, which probably would be given to to the Commission, and this would make this a little bit more feasible. The problem is, of course, again, even if this is some kind of a regulation made practically by the Commission or by the Council with the consent of the European Parliament, the question is whether it is in compliance with the treaties. Maybe it is unconstitutional, as the treaties does not provide for such action. So if we have such an attempt to regulate, this case may well finish and end before the European Court of Justice, and we may have a very interesting procedure before the European Court of Justice, whether it is allowed under the treaties to condition money by observation of rule of law or not. Then another concept is to extend the scope of the infringement proceedings. Traditionally, as I mentioned, infringement proceedings were meant to be a reaction on, let's say, regular but not very drastic violations of the treaties. Now, the position of the doctrine has always been it cannot apply to Article 2, because Article 2, this is a little bit too general to be enforced in the infringement procedure. Now, there is more and more proposals that the court should accept, that Article 2 also may be enforced via infringement proceedings, which would somehow judicialize the whole problem, which probably would be much more digestible politically than to leave it to be decided by the political branches of government. But this is again some kind of a question mark. So, where are we? That I don't know, of course. As it is usually said in such situation, the process is dynamic and it changes from one month to another. Everything, of course, will be decided finally by within the area of realpolitik. The political question is to what extent those countries who run the European Union, and of course it's not necessary to make a short list of these countries, would be interested in imposing some sanctions on Poland. Of course, it would be very attractive to restore rule of law in Poland from the moral point of view, but from the economic point of view, this is also a little bit complicated because, as I've mentioned, Poland doesn't make any problems as far as its economy is concerned, with a long list of other members of the EU which are making problems as far as their economy is concerned. The question is to what extent it is in the interest of the EU to open another front of a country which may have economic problems. So, morality or realpolitik? Again, difficult to tell. Everything is possible. But it seems that the European Union was confronted with a kind of a crisis which was not incalculated by the drafters of the treaties. The drafters of the treaties were well aware that there may be different economic problems, but even then they were unable to foresee the whole scale of the crisis on the beginning of this decade. But they were not able to foresee that there may be also a political crisis in which some countries would slide back toward some, let's say, quasi-authoritarian rule. The EU is not well equipped for this answer. Again, and assuming that there is a political will in the EU, probably it would be possible to compel these naughty boys to behave. But as long as this political will is not there, it's also possible to say that the EU should not intervene. Finally, the EU does not have jurisdiction over everything. Its jurisdiction is also limited to those areas which are enumerated in the treaties, and except for this general Article 2, confirming some values of the Union, the rest of the Union law is not oriented toward judicial organizations and the other, let's say, aspects of rule of law. It's always meant to be left rather to the internal decisions of the member states. So we have several question marks concerning the Brexit procedure. We have several question marks concerning the countries which do not behave in the Union. We do not have too many answers as yet, but it makes, of course, academic discussions more interesting on this point. Thank you.
We have time, about 20 minutes for questions. That's okay.
Thank you very much, Judge Garlicki, for the extremely interesting presentation. I would like to maybe ask the audience here, including me, would like to learn more about the details of what actually happened to Poland, which gave rise to the concerns of the EU and criticisms and warnings and so on.
Well, what's happened was a series of moves which were constitutionally problematic and which were meant to allow the winners of the elections of 2015 to concentrate as much power as possible. Again, the election allowed this so-called Law and Justice Party, allowed them to take what there was to be taken, namely both chambers of the parliament and the president, meaning, of course, also the government, prime minister, etc. The whole constitutional system was created on the assumption that this, of course, is possible, even if not very probable that one party would take all, but there should be other segments of the government which are separated from the current political change. The judicial branch, the agencies dealing with public radio, public television, the public propaganda system, the ombudsman, and so on and so on. Now the new majority immediately decided to adopt a series of laws intervening into this technically independent authorities and taking these independent authorities under their control. Again, as it was rather clear that this is constitutionally problematic, the first target was the Constitutional Court. And this was not easy, this took 1 year. But finally, after the 1 year, the new government was able to get a majority in the Constitutional Court and practically to eliminate the Constitutional Court from any chance to exercise more independent position. Now, the next target is the rest of the judicial branch, and unfortunately it seems that at least in part it has been already achieved. The same was applied to radio and television stations, for example. The public radio and television is under full control of the new government. So this is a slow process, but still very clear process of expanding the political majority from the control of the executive and legislative branch towards the overall control over the whole mechanism of the state. And this is something which, of course, is completely incompatible with the very idea of rule of law, democracy, as it existed until now in the European Union.
Other questions?
Professor, sorry. I mean, if they came to power through through elections, is there a possibility that they might be thrown out also through the election process?
Yes, as long as they are not able to change electoral laws, which also is at least theoretically a possibility. But this is not a problem, because again, as long as the economy is doing very well, the population is happy. And then today, after all these awful things I was talking about, the opinion polls give the Law and Justice parties well over 40% of support, which is astronomical for Polish conditions. So this is not necessary even for them to doctor some electoral laws. Technically it's possible, of course, to lose elections, but probably not the next elections, maybe elections after next. But at least as long as there is no economic catastrophe, this party is generally regarded as doing a very good job, and that some judges would lose their positions, who cares?
Can you tell us what the position is in Hungary?
Hungary, there is also the one party, Fidesz, which is in control. The difference is that they have constitutional majority. So after 1 year of being in power, they managed to adopt new constitution, avoiding most problems our Law and Justice party had with finding some, let's say, quasi-constitutional way to get what they want and not to offend the constitutional provisions too drastically. But I think Orban is, I mean, Hungary and Orban, they have slightly different way of expressing their policies and their preferences. They are not so confrontational, particularly in relations with abroad and with relations with the European Union. The Polish Law and Justice Party is very confrontational. Apparently the calculation is that it would generate more support of the electorate. I don't know. But this is probably one of the reasons why Hungary managed somehow to get away with what they were doing, and Poland provoke more, let's say, reaction or more barking from the side of the European Union.
So on the scale of to bark or to bite, how do you evaluate yesterday what happened? I mean, the non-binding resolution that was passed by the European Parliament in support of action taken against Gaza.
Well, this is a necessary step, because again, if we want to have this formal warning procedure to continue, the first step is the motion of the Commission, then it had to be approved by the European Parliament. So there is the approval of the European Parliament, but what next? So this is still more on a bargaining side. Again, my private assessment, but of course it is not particularly valid, is that these formal procedures, it's not very probable that they would lead to some kind of binding. But the informal procedure, particularly all these arrangements dealing with a budget, with funds, with distribution of funds, with execution or other implementation of funds, This may offer a lot of possibilities, let's say, of a hidden biting. It is not, it will not be proclaimed as a sanction because you are not a, you do not behave like you should, but nevertheless, there may be some painful effect if some money is taken away from some program or from some funds. So in this respect, biting, I can easily imagine how serious, again, this is the question of realpolitik. How far Germany, France, the UK, as long as UK has anything to say in the Union, would simply accept such a change in the policy.
I have a question about the more realpolitik side of the EU. So why do these EU values, such as the rule of law and democracy, why do they have to be part of the EU deal? What are the political benefits and incentives that have compelled EU states to make all EU states comply with these EU values? What are the benefits of doing so?
I think there are two, again, dimensions of this of this answer. The one more pragmatic dimension is that there is a very strong belief that a country which is not democratically ruled is not reliable economically. So the sad experience of communism showed one lesson without any reservations. Authoritarian system means a ruin of the economy. And this is, of course, something the European Union cannot afford as far as the members of the European Union are concerned. To what extent such lesson is true, I don't know. China is apparently an example that it does not work outside Europe, and that you may have a system which is not extremely democratic, but still economically quite successful. So of course, but this is something which, of course, is not so important from the European perspective. So this is the one idea. Then, of course, there are several, let's say, also pragmatic, but maybe less basic arguments. For example, the system how the EU law is implemented is mostly by national authorities. So practically, each case of controversy resulting from the implementation of the EU law is decided by national courts. If national courts are no longer independent, the question is whether the system could work at all. We have to keep in mind that in many cases they are also parties or interests from other EU countries or from EU as such. If there is no guarantee that these cases or controversies would be decided in a, let's say, fair and honest manner by the courts, then again the whole system may stop working. So there are pragmatic arguments, and then there are moral or historical arguments. Again, Europe has some kind of allergy on totalitarian regimes because it was well experienced in the communist countries, but there was also well experienced in Germany, in other countries. So this is something that politicians, at least of my generations, are very afraid of. And finally, of course, there is also this moral argument, simply that a decent country of the European Union must be a country observing some values. If not, this country should not be in the European Union, simply.
I have a follow-up question in relation to the question just posed by this gentleman. For the way forward, how far do you think the compliance with the rule of law, or how far do you think the member states are aware that the compliance with the rule of law will be beneficial or essential for the future of the EU?
Again, compliance with the rule of law, independently of its, let's say, human rights or democracy dimension, is something without which the whole system of the EU cannot work. again, implementation of EU law on the domestic level cannot work if there is no rule of law and no independence of the court. So this is let's say one side of the story. On the other hand, well, this is really a very complicated problem from the theoretical point of view, because this, let's say, authoritarian or quasi-authoritarian governments, they did not take power by some coup d'etat. They were democratically elected, and even more, they still have a legitimation of clear support of the majority of the population. So now, to what extent other countries should have a right to intervene? Well, the very essence of the European Union is that it should have some rights to intervene. But to what extent? Where is the end of this? Again, those questions has never been addressed before because they never have been, let's say, so clinically visible like now that we have the problem, I called it backsliding, but this is democratic backsliding. One can say populistic backsliding, but still, at least as far as until now, elections in both countries were fair elections. And this parties won because they had support of the majority, or rather because the other parties simply were completely disintegrated. So this makes this whole story even more complicated. To what extent the European Union may intervene into such decisions? Probably it should. But we have to find some new theory of legitimization of such interventions. And you also should keep in mind that if there is a precedent of the Union intervening in such situation today, when it is justified, necessary, could be helpful, etc., then all countries understand that it may be applied again, maybe in a different situation. So also not all EU countries would be very happy seeing EU institutions extending or expanding their powers to intervene into areas which until now has never been explored by them.
I have another follow-up question. I'm not sure how willing you are to predict the future, but to what extent, what is the likelihood that you think one or another scenarios might actually play out?
No, I think what is probably more, more probably some kind of a settlement on a rather low level as far as what Union is going to request. My feeling is that this realpolitik may win, providing Poland will be able to give some guarantees, for example, for let's say unimpeded functioning of EU law. So this is the optimistic scenario. The pessimistic scenario is that the real intent of these political parties who are controlling the situation in Poland or in Hungary is to take this country out of the European Union, which is not unimaginable, which would, in my opinion, it would be a catastrophe, but it's not. It would be not the first time when a country decides on its own democratic decision to commit a suicide. So this would be a pessimistic scenario, but again, this is not a scenario I absolutely am absolutely ready to qualify as a fantasy.
Time for one more.
Considering that rule of law is to be modified in a way to promote democratic value, so how does this modification address the rise of extreme right parties that is happening in many nations in the EU members? And if it is to promote, it is to undermine the rise of these extreme right parties, how would it be, in a sense, being democratic?
This is this concept of so-called militant democracy in Europe, which was elaborated after the Second World War, that still democracy must not result in self-destruction. So some extreme orientations and some extreme actions should be stopped, even if they have support of the electorate or some kind of democratic legitimation. At least democratic institutions should not be abused to be distracted by such action. But this is all nice. This is also all nice theory. The implementation, if this is as well, it's relatively easy for a state to fight the extremistic parties. A party may be dissolved, the leaders of the party may be removed from the parliament, etc., etc. But if the whole government, whole country, follows some kind of, still very mild, but still authoritarian tendency, then there is a problem. Because then there is no check within the country. The only possible check is an external check, but the whole international law is built on the assumption that the other countries must not intervene unless there is a direct threat to peace or security under the UN Charter. But of course we are very far from such a situation.
Okay. Could I ask a follow-up on Hungary? Are these the only two offenders, Poland and Hungary, or are there other countries in danger, such as Romania and Bulgaria, and maybe Slovakia and the Czech Republic?
I think that now this is even not limited to this part of Europe. I have an impression that before any elections in any European countries, there is a lot of nervous calculations whether the extreme right may win. You remember this suspense before the French elections, before the Dutch elections, so countries which apparently have always been the last candidates for such. We have Austrian elections, not very successful from this point of view. Okay, Germany, it's still a good scenario, but Italy it may be more complicated. So this may be contagious. This may be contagious, maybe not in sense of duplicating such authoritarian schemes, but it may be contagious in duplicating some anti-European schemes. And then, of course, may be very dangerous for the Union as such.
Okay, I'm afraid we're out of time, but as the title promised, it's been an intriguing presentation. You've raised a lot of very important questions, question marks, as you put it, and hopefully you can come back next year and give us an update, and things will, one of the more positive scenarios will be playing itself out at that stage. And thank you all for coming. Please join me in thanking Lech Garlicki for his.
Thank you very much.